Politics of Genocide, Darryl Li will be speaking. Do we have a connection? Mr. Li, do you hear me?
Yes, I can hear you.
Okay, thank you. The time is yours.
Thank you. My name is Darryl Li. I'm a legal scholar, international human rights lawyer, and anthropologist. I lived and worked throughout Palestine, including in the Gaza Strip. I'm here in my capacity as an expert on international law, settler colonialism, and the question of Palestine. In the 10 minutes I have, I will address some of the problems stemming from the Genocide Convention, the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, to be precise, and how some of those problems have manifested in the proceedings before the International Court of Justice, the ICJ, concerning Palestine. Over the course of these proceedings, here in Istanbul and virtually, the jury has heard overwhelming evidence that the State of Israel has committed numerous acts that, under most reasonable interpretations of international law, meet the definition of genocide. I will not belabor that point here. Instead, my task is to remind you that law, including the law of genocide, is not made or interpreted in a vacuum of objectivity free of politics. I'll do my best to provide a map of the politics of genocide and genocide accusations and the duopoly that the United States and Israel have sought to maintain over the term for decades. And I will remind you that it is people, not courts, and movements, not jurists, who remain the ultimate worldly arbiters on what is just. I'd like to show the jury only one image today. These are two hilltops on the western outskirts of Jerusalem. At the bottom of this image is Yad Vashem, the State of Israel's National Holocaust Memorial, a site of pilgrimage for visiting dignitaries and schoolchildren alike. At the top of the image, barely a kilometer away on a neighboring hill, is the spot where the Palestinian village of Deir Yassin once stood. Deir Yassin was the site of one of the most infamous massacres of the 1948 Nakba, and some of its stone homes are still standing as they have been repurposed by an Israeli mental health hospital. So the most famous monument to the most widely commemorated mass atrocity of modern times sits adjacent to an actual site of mass atrocity whose memory is actively repressed every day. 1948, of course, was not only the year of the Nakba. It was also the year that the international community adopted the treaty that would enshrine genocide as a crime under international law. Many of the states that signed the Genocide Convention of course, had committed mass atrocities of their own. Thus, care was taken to craft a legal definition riddled with enough ambiguities and loopholes to afford states a degree of plausible deniability. Thus, a chasm emerged. Morally and ethically, genocide came to be known as the crime of crimes, a superlative form of mass atrocity that should generate unconditional, absolute, and universal opposition. On the other hand, genocide had a narrow and highly technical legal definition around notions of specific intent and protected groups that left it open to manipulation by states. Powerful states could thus use genocide as a rhetorical cudgel against their foes while avoiding accountability for themselves and their allies. The State of Israel has for decades mobilized the memory of the Shoah, or the genocide of European Jews by the Nazis and their allies, as a justification for dispossessing the Palestinian people. According to this logic, European Jews have survived history's greatest crime, and therefore any crime Israel commits is necessarily trivial by comparison. For its part, the United States, especially from the 1990s onward, has repeatedly referenced its role in liberating the Nazi concentration camps to argue that it has a unique responsibility as the most militarily powerful country on earth to combat genocide around the world. According to this logic, the United States ended history's greatest crime, and therefore any crime the United States commits is necessarily trivial by comparison. Of course, these arguments are profoundly misconceived and ahistorical. They erase the collaboration between the Zionist movement and the Nazi regime. They erase the wartime refusal of the United States to accept Jewish refugees fleeing persecution. They erase the role played by the Soviet Union in defeating Nazism. And they erase the fact that the United States is itself a settler colonial state founded in genocide. Nonetheless, the jury should take note that the United States and Israel have forged a rhetorical duopoly over genocide to justify their respective agendas, portraying Israel as the ultimate righteous victim and the United States as the ultimate righteous avenger. The jury will be aware that over the past 2 years, the politics of genocide have been challenged like never before by the events in Palestine. In December 2023, the Republic of South Africa instituted genocide proceedings against Israel before the International Court of Justice. The following month, the ICJ issued a preliminary ruling finding these claims to be plausible. It also ordered Israel to refrain from violating the Genocide Convention, but it did not heed South Africa's request for an order directing Israel to end the war on Gaza. As the situation in Gaza continued to deteriorate, the ICJ dithered for months before belatedly demanding a ceasefire only around Rafah, which Israel blithely bulldozed aside like so many Palestinian homes. Since then, the court has been largely quiet as it considers the arguments of the respective parties, including the numerous intervening states. On the one hand, the inability of the ICJ to stop genocide is a reminder of the gap between the aspirations of international law and the realities of power politics. On the other hand, the expectation that any court can simply make a declaration and expect powerful states to automatically fall in line perhaps puts too heavy a burden of expectation on courts in the first place. There is no law in the world that is self-executing. To the extent law seems to work properly, quote unquote, it is because there is a political arrangement that makes it possible. This is not to defend or make excuses for the ICJ. It is to remind you, the jury, that at the end of the day, it is popular mobilization that supplies the conscience of humanity and that can build power to achieve justice. The ICJ's preliminary ruling shattered the taboo around accusing Israel of genocide. It radically reshaped the contours of public debates in the West, and it irreparably damaged Israel's ability to assume moral supremacy. It provided activists around the world a powerful rhetorical tool and helped legitimize their cause. I want to stress that this outcome was not a natural or inevitable response to the scale and brutality of Israel's actions. History is full of many examples of mass atrocities committed in plain sight that elicit far more muted reactions. Rather, it was popular mobilization that made it possible. The steadfastness of the Palestinian people in the Gaza Strip, from Beit Hanun to Rafah, has inspired a global solidarity mobilization that has challenged the US-Israeli duopoly on the genocide concept, and with it, their ability to tame public criticism. This mobilization, of course, has come at steep personal cost, first and foremost for Palestinians themselves facing genocide, and to a far lesser extent, those protesting across the world who have faced the truncheons of police and the loss of livelihoods. Nonetheless, we cannot relent. While the consensus in the human rights community that Israel has committed genocide grows stronger with each passing day, it is not inconceivable that the ICJ may ultimately absolve Israel of the charge. Of greatest concern here is that it may adopt the absurd theory that an act can be considered genocidal if the only possible motivation is to destroy a protected group. This could rule out, for example, the notion that a state might be pursuing a political goal of defeating an enemy army concurrently with trying to destroy the civilian population. Under this standard, for example, the genocide in Rwanda would not be considered a genocide. Once again, it is only sustained popular pressure, including through venues like this tribunal, that can push the ICJ and other institutions to align themselves with justice. Thank you.